Okay guys, welcome once again to another episode of Score Talks Law. So this is an episode whereby Score Talks Law, and in this episode we're going to talk about the classification of evidence. So evidence is classified under two main categories. We have public evidence and private evidence. So those are the two main categories of classification of evidence. So private evidence, this is that evidence that has been authorized by public or private individuals in their private capacity. So these are documents that are authorized by those either public or private individuals in their own private capacity. So section 79, all documents other than public documents are considered to as private documents. That's according to the provision of section 79 of the Evidence Act. So under private documents we have two categories. We have primary private documents and secondary private documents. So primary private document is that document that has been written manually. It's in its original form, while secondary private document is that document that is an extract from the primary private document. So there is this evidence, the best evidence rule, and according to the best evidence rule, it states that the only evidence that can be admissible in court is that evidence that is in its primary state. An extract from the primary document cannot be admissible. That is according to the best evidence rule. But you'll find that this best evidence rule has been criticized, has been ruled against in several cases. So Lord Denning, in the case of Gatton versus Hunters, 1969, 2QB37, Lord Denning said about the best evidence, said this about the best evidence. It's plain that Scott LJ had in mind that the old rule that a party must produce the best evidence that the nature of the case will allow, and that unless that any less good evidence is to be excluded. So Lord Denning said that it is plain for Scott to say or demand for the provision or production of the best evidence rule. So any evidence other than the best evidence rule, other than the best evidence, any less best evidence rule was to be excluded. That is according to Scott LJ. But Lord Denning is against this rule of excluding any evidence on these grounds of best evidence rule. And according to Lord Denning, admissibility and relevance of evidence should be determined in the admission of evidence. They should consider the admissibility and the relevance of that evidence instead of considering the best evidence rule. So according to Lord Denning, the remaining instances that I know is that if an original document is available in your hand, you must produce it. You cannot give secondary evidence by producing a copy. Nowadays, we do not confine ourselves to the best evidence rule. We admit all relevant evidence. So all relevant evidence should be admissible according to Lord Denning. No need of the best evidence rule. So in Kajala versus Noble, a 1982 case, 75 Criminal Appeal number 49, Akna LJ said the old rule that a party must produce the best evidence that the nature of the case will allow, and that any less good evidence is to be excluded, has gone by the board long ago. The only remaining instance of it is that if an original document is available in one's hand, one must produce it. That one cannot give secondary evidence by producing a copy. Nowadays, we do not confine ourselves to the best evidence. We admit all relevant evidence. But the badness or the goodness of evidence goes to the weight and not the admissibility. So the badness or the goodness of evidence, particular evidence that is admissible, it goes to the weight of that evidence, but it should just be admitted on grounds of relevance and admissibility, not on the grounds of best evidence rule. and then the weight of the evidence will determine whether a particular party wins a particular case or has those legitimate grounds, and so not on the grounds of the best grounds of best evidence rule. So the other category of private evidence is the secondary. So public documents are those documents that can be accessed by the public. They are documents of sovereign authority, documents drafted by public bodies or individuals. Public bodies like the legislature, executive, judiciary. The public bodies are the ones that draft these documents. So these are documents made for the public, the purpose to be retrieved by the public, or they are documents that are available. So that's all you need to know. That's what you need to know about the classification of evidence. So just stay tuned for more episodes are coming. Subscribe to Scott's Legal channel, like the episodes, comment on the comment section on how you feel about the lectures, on how we should improve the lectures, on how we should be conducting the lectures, because your opinion will be received and will be responded instantly. So subscribe to Scott's Legal channel.